will be joining us soon. So I will be giving the introduction, short introduction on behalf of warm welcome to everyone. So recent amendments in amendments in CPA, newer judgments by various courts. So we'll be having a IC on our medico-legal aspects. So these are, as we all know, very turbulent times for our ophthalmic practice, and such headlines are very common nowadays. Every week or every month you will open and you will see a new headlines that so and so doctor has been sued for such and such a compensation award has been passed. So in keeping with the theme, we have got esteemed panel with us. So for that we will be having our first speaker, Dr. Pankaj Shah. He is a past treasurer of Maharashtra Ophthalmic Society and very high volume surgeon from Jalgaon, and he'll be speaking on Consumer Protection Act 2019, what has changed for the ophthalmologist. Thank you.
Good afternoon, all of you. I thank Dr. Viral Shah for including me in this IC. As mentioned by Dr. Viral, really, we ophthalmologists, we doctors are facing tough times medico-legally, and we all should be aware of the things going on about the laws, scenarios, and the conditions where the law is applicable and what way we should respond to the same consumer protection notice or an. So briefly, I will be discussing about Consumer Protection Act 2019 and what has changed for the doctor or for an ophthalmologist. The first law which was there, it was in 1986, and then the new amendments were made in 2020, but still it is known as 2019. There was a lot of debate whether medical fraternity is added in this law or not. There were rumors that medical fraternity is not applicable, or this law is not applicable to medical fraternity. But the law has not mentioned anywhere that medical services are excluded. And once it is not there that these services are not excluded, then it has to be taken that this law covers medical fraternity also. So what are the things which has been changed from the last law and this law? The compensation amount initially, which was in lakhs, has now increased into crores. But the good thing is that it is as per the bills produced during the consumer action or whatever complaint has been lodged. The other thing was that initially it was the jurisdiction where the patient was operated or where the surgeon was there, but now the complaint can be lodged anywhere in the India. Suppose the patient is from Cochin and I am in Kolkata, the patient can lodge complaint in Cochin also. Other thing is they have provided a consumer mediation cells for this. It can be good and it can be bad. If you want to solve, there can be mediation cells. Mediations can be done by agencies, but undue advantage is been taken by the agencies. They are trying to go for compromise. So in some way or the other, doctors, as they are always a soft targets, can always fall prey to all these mediations. So we have to take it with a pinch of salt. Yeah, now this law has turned up relationship of doctors and patients. Initially there is a doctor-patient relationship, but as per the Consumer Protection Act 2019, now doctors are professionals. they come into the category of business and sellers. Whereas patient initially was a client, but now patient also comes into a buyer and a consumer. As per the law, it was thought that it will be pro-patients, definitely, but it is anti-doctor. But mind that though it is anti-doctor, patients are also equally receiving the bad taste of it. Because when this law has come and we are aware of these things, we try to safeguard our interests also. So for medical legal protection, the diagnostics have increased. We have increased our investigations. We are advising CT scans, MRI, just to safeguard. Then also chances of second opinion, the patient or we also recommend take second opinion. We are somewhere or the other going into defensive practice mode. The practice, the faith which patient had now has converted into suspicion. They look as suspicious on always whatever we comment. So equally the patient is affected and the doctor is also affected. In this law, where is doctor answerable? Yes, he is answerable to the medical council, to civil court, to criminal court, to consumer redressal, Janta Darbar, and this answer can be simultaneously or sequentially. So what is this act? It is a special law of civil nature with the aim of social welfare to protect consumers with following features. Initially it was proposed that there won't be any court fee, but now it is almost up to 5,000 rupees. The procedure is simple of filing, hearing and deciding. There can be a summary trial and a redressal, speedy redressal also can be there in this act. So who are the judicial members on this forum? Compulsory there has to be one female in this. It is not a court as a full force and hence it is known as quasi-judicial. And the opinion of all the members is the order of the forum. Act is compensatory, that is the thing, and it's not preventive or punitive. Again, it applies to all goods and services covered. But the free services which are covered are the only medical services which they have covered as a free. So you are offering any service or you are operating free, but still this law will be applicable and patient can file a complaint against you under Consumer Protection Act. Initially, the jurisdiction was as per the compensation amount. District was almost equal to or less than 20 lakhs, but now compensation up to 1 CR can be at the district forum. About hundreds lakhs or more than 100 lakhs, 1 CR will be state commission, where there can be appeals plus administrative powers, and national will be more than 10 CR. So that is a good thing. Many times initially we had to go directly to the national commission, but if the claim is of more than 10 CR, then only national commission has to be there, and there are no power of reviewing its own order. What is the period of limitations? Yeah, the period of limitation of the complaint is 2 years, and for appeals is 30 days. Even condonation is possible in this. What is the procedure of filing? So it is a summary of the procedure has to be done. The complaint has to be in 4 to 6 copies affidavit. That has to be referred to the opposite party, and opposite party is expected to reply in 30 days. Additional 15 days grace period can be taken. The law, whatever hearing, it has to be by the president and one of the member of the forum. Lawyer is not mandatory. Evidence on affidavits, expert books, references, if elaborate, may be asked to go to civil court also. And the order which comes has to be signed by president of the committee and one member. If doctor is not available, but still ex parte decision is possible in this act. What are the appeal systems? The first is the district forum. If it's not resolved there, then state commission, then national commission, and if it's not solved in national commission, it can go to Supreme Court. So what are the proposed changes? There are power of interim orders, power of injunctions, increasing the pecuniary jurisdiction. National commission is only appellate jurisdiction, and more benches of state and national commissions are there. So if we compare the old act and the new act, you can see the domain. Here all goods and services, including free services, are added in the new act. The pecuniary jurisdiction has changed as per the claim amount. Territorial jurisdiction, again, where complainant resides or work, can also file from his place. Regulatory body, it is a Central Consumer Protection Authority to be formed. And initially there was no mediation, but there can be a mediation agencies in the new act. Price initially was the MRP in old act, but now it can as per the bills produced. All provisions to direct sellers to extend to e-commerce as well. And if a person does not comply with the orders of the commission, he may face imprisonment up to 3 years or a fine of not less than 25,000, extendable to 1 lakh or both. So what I always believe is, first see the patient medico-legally, then technically, and then comes empathy. I suggest to do work honestly and sincerely, but never allow the honesty to get into your head. Consider ourselves like any other profession. We don't have any extraordinary privilege in the country. And in fact, we are more vulnerable and easy targets than anyone else. Don't get by the terminologies like noble profession, God, life saver, doing charity, feeling good. These words were apt in the past, not now. Be honest and accept the reality. Thank you.
Yeah, Pankaj, you have very well summarized the topic, the vulnerability of our doctors to the consumer. So patients are not patients now, they are consumers, and we are like businessmen, so we have to act accordingly. Now the next talk is by Dr. Viral Shah, landmark judgments by courts, lessons to be learned from themes and ophthalmologists. Dr. Viral, who is the chief organizer of this IC293.
Thank you, sir. So as rightly summed up by Dr. Pankaj Shah, Consumer Protection Act has not barred us or has given us any immunity after its amendment in 2019, and there are some landmark judgments by court through which we have to learn some important lessons. So every one of us has faced a legal notice, and all of us fear about some legal actions in the future and lose some sleep over it. And if we don't learn from history, we are doomed to repeat it. So Supreme Court judgment on CPA 2019 held that the mere repeal of the 1986 Act by the 2019 Act without anything more would not result in exclusion of healthcare services rendered by doctors to patient from the definition of the services. So it is settled in this court judgment of Bombay High Court. Service rendered to a patient by a medical practitioner would fall within the ambit of service as defined in section 210 of the Act, and it would not exclude the service rendered by them from the ambit of the Act. Consumer Protection Act has laid down some broad criteria for doctors. It is duty cast upon doctor to provide the fact that no sort of negligence took place inside the OT. How much to charge as fee for medical services is the choice of the medical practitioner. Doctor is not entitled to approach consumer forum for recovery of professional fees. So if the patient doesn't give you fee, you cannot go to consumer court. You have to go to civil court or whatever action, other criminal court. Fees paid for operation also includes post-operative care. So also death on table and direct arrest of doctors, these are all well settled. You cannot arrest directly a doctor on complaint. You have to go through IMA local body and through our government college or CS. If they give a report that negligence there, then only they can arrest it. Case can be filed, but arrest of doctor is stayed. Also same regarding death on table in the Jacob Matthew case. So it is no longer a cognizable offence but a bailable offence. Judgment, some landmark judgments by state and national commissions which protects or helps us ophthalmologist. I will take this first and we'll go to the other part later. So it is not negligence if the nucleus drops occurs and if removal is not feasible. It is not possible to determine the exact power of oil before surgery, so a post-operative 90% may require additional glasses. If dislocation of oil takes place, if patient does not follow the instruction of doctor, and as a result benefit of operation are reduced. Eye surgeon performing YAC PI to rectify IOP and there is subsequent vision loss, and if a patient gets an infarct while doing a minor operation. We will take some examples. So the complainant suffered a PCR with nucleus drop at the time of cataract surgery. There was delay in the second surgery to remove the lens, dropping an IOL implantation as patient had undergone uncontrolled sugar. Further, patient had RMD and DM, and she was counseled as GVP. The ophthalmologist submitted extract of textbook, and under the head of other complications, it is clear-cut mentioned that posterior capsular rent with vitreous loss is one of the complications of cataract surgery. So is nucleus dropping through PCR. In this case, the complainant did not produce any evidence or create circumstances to hold that the doctor did not take reasonable care, degree of care and skill in conducting the operation, and therefore the said decision supports the case of the doctor. One more case, we have withhold the names of the doctors because some of them are also there in this campus. So on 17th of October 2007, the patient underwent IOL implantation under the doctor's care. Post-operatively, he did not have clear vision and refraction showed error of +14 diopter. Most of the investigation relating to the eye problem and selection of lens with its power was done through sophisticated machines. Best possible treatment to patient was provided, and all sorts of care pre and post eye operation was taken by this institution. Patient underwent IOL exchange at another institute, after which he filed a lawsuit. No expert opinion or medical test have been produced to prove the selection of IOL was faulty through the A-scan machine, and implantation of said lens by the doctor was wrong. After cataract surgery and IOL implantation, dislocation of the lens was noted by another specialist 2 weeks later, who explanted the lens and implanted SFIOL. This was not noted by the first operating surgeon due to high grade of cataract preoperative and due to postoperative corneal edema. ILMP was also done. Patient did not follow up properly postoperatively and directly consulted the second specialist. Consumer Protection Forum concluded that IOL dislocation was a known complication of surgery and that patient was contributor negligent in not following up properly. The court further submitted there are no expert opinion or document to prove negligence on part of doctor number 1 and 2. In Uma Tiwari versus State of MP case, patient had an attack of primary angle closure glaucoma for which YAG was done, following which she developed CRVO and claimed negligence on part of the doctor. Court held that doctor was not negligent as he was the best judge who at the spur of the moment to carry out laser treatment instead of anti-glaucoma medication in order to ensure that there is no damage to the retina and no loss of vision takes place. The patient was explained regarding YAG PI procedure and its complication. Patient vision was deteriorated because of CRVO. The cause may be hypertension, but the patient did not take any treatment for hypertension at that time. In writ petition civil number 1247 of 1986 Supreme Court, these are some landmark judgments against conduction of camp, and guidelines for the camps were laid down after this case. The Supreme Court laid down guidelines for conducting camps. So Lions Club in Khurja, UP conducted and opened an ICAM at Khurja after obtaining necessary permission from CMO. And a team of doctors under Dr. XXX was invited to the surgical job. The club published propaganda literature with attractive slogans: get operated and go home, no restriction on food, no bed rest, no stitches to be removed. In response, thereto substantial number of patients visited the camp. 108 patients were operated and 84 developed endophthalmitis. The fault was in the saline bottle procured by government authorities. Government was asked to pay compensation of 5K to each person, and after this the following guidelines were set. Compensation was that there was no approval to run the hospital, consent to operate was not taken from the State Pollution Control Bureau, and there was no proper design and maintenance of the operating room. There was no anesthetist, no pharmacist, and no facility to do post-operative lab test, and there was no formalin which was indented despite it being out of stock by the head of the hospital. Court also found about the fact that knowing fully well that IOL costs only ₹56, for the purpose of enticing villagers, they had distributed pamphlets stating the cost of the intraocular lens will be 1,000 to 3,000 rupees. Despite Pseudomonas having been cultured from the ringer lactate being used from the manufacturing company was absolved of any wrongdoing because the sample was sent for test which was of some different batch and it was found to be satisfactory. So the guidelines that were set after this landmark case was a qualified experienced ophthalmic surgeons registered with Medical Council of India or State Medical Council should only perform and supervise the operation. Camp should not be used as an unsupervised training ground for PG students. There should be a pathologist to examine urine, blood sugar, etc. It is preferable to have a dentist to check the teeth for sepsis and a physician for general health checkup. All medicines, consumables to be used should be of standard quality, duly verified by the doctor in charge of the camp. In this interesting case, a cataract surgery was performed on 66 patients at a reputed hospital in South India. 61 lost their complete vision in the operated 66 patients. Out of 66, 61 lost their complete vision in the operated and 5 partially lost the vision. 61 were fully blind and 5 were partially blind. The Chief Judicial Magistrate which heard the case convicted Dr. X, Director of XX Institute, CMO and Chief Administrator under Section 338 of culpable negligence and endangering the personal liberty of the patients. Court also ordered a payment of compensation to the victims ranging from 2.28 lakhs to 5.17 lakhs according to victim's age. So this case was used as a compensation was fixed as per the Workmen's Compensation Act for the first time in ophthalmology. So Workmen's Compensation Act, according to your age, you will be given compensation was used as a scale for this case, and it is now applied in every cases of compensation. So it's a vicious cycle, cost to be paid even for providing free services. It is now time for us to introspect where we are and what further course we have to take. With exceptional high compensation being granted today by the Indian courts for loss of vision even against government hospitals, the alarm bell should start ringing a long time ago. In V. Krishna Kumar versus Tamil Nadu judgment, 2.65 crores as compensation, including 6% interest in this case for failing to diagnose a case of ROP. So in this, the implication of this judgment for ophthalmology is in terms of quantum of compensation being awarded for loss of vision is enormous. Such is also for refractive surgeries. Recently, a patient following LASIK surgery for high myopia underwent toric implantable ICL, and for unsatisfactory results claimed a sum of rupees 6 crores as compensation. Thankfully, the court did not agree to such exorbitant claim, especially when the boy completed higher education after the surgery and was gainfully employed and was very active on social media as found by the investigator hired by the hospital. So the court dismissed the plea. Obviously, this is again one more Pandora's box of level use of drugs. Especially nowadays, we have been using anti-VEGFs. It is well established that Boehm's test must be applied, and doctor might be able to avoid a claim for negligence if he can prove that the other medical professionals would have acted in the same way. Medical records, will be covering this in the next talk by Dr. Rajesh Joshi, medical records and ophthalmologist. Also, poor record is always a recipe for disaster, and also indemnity insurance. Agrawal sir will be highlighting these points. So, in short, indemnity insurance is must for all of us, and it should be the quantum which should be decided. We will get details in from Dr. Santosh Agrawal sir. So, thank you so much for attending this IC. And now I will invite our next speaker. Dr. Manoj Khatri has joined us from Chennai, and is a consultant at IDOC Hospital and also visiting consultant at Apollo and Mohan Rajan Eye Institute, and is a member of Managing Committee of VRSI and Tamil Nadu Society. Welcome, Dr. Manoj.
Thank you so very much, Viral, and the entire panel here, esteemed panel, as well as AIOC, to give us this opportunity time and time again to conduct this course. I think year on year, successively we are conducting for last several years. So the topic aside today to me was medico-legal aspects of teleophthalmology. Where do we stand today? I think no ophthalmic practice is without of use of technology nowadays, and though we wanted to have a good show of hand, I am quite sure that all of us are today using some kind of technology in our practices, and we should also be well versed with what are the medico-legal aspects of which can arise. Nil financial interest is my talk, but you should always be financially protected, has been highlighted by Dr. Viral and will further highlighted by Dr. Santosh sir, so that if any undue thing happen in future in your practice, it can be legally as well as financially covered for you. So what do we mean by telemedicine? Let's understand few terminologies here, because this is where the court of law will hold you guilty against of any wrongdoing or any mishap. So WHO tells us that telemedicine is any delivery of healthcare services using information and communication. which can be in form of technology for the change of valid information for diagnosis, treatment, and prevention of disease and injuries. It can be even for research and evaluation, and for the continuing education of the healthcare providers with distance is a critical factor here. So this is the basic definition. Few of the differences, telemedicine, here the healthcare professionals and the patients are distant. Okay, the patient is not sitting in a clinic. Telemedicine allows us the reliable transmission of medical information through text, sound, images, whichever way you want to use it for the prevention, diagnosis, treatment, and monitoring of patients. And the accessible healthcare is the real goal of telemedicine or teleophthalmology as per se. So in which way telemedicine in ophthalmology can be practiced in different formats? I've taken just few main formats on which platforms we are already using it. So we are using it for access of healthcare to patients in the remote area. So this is mainly through CAM-based screening. Patients seeking second opinion. This is one of the major chunk of patients. And this can be cross-border or even cross-country. Preventive medicine by giving patients information on their health condition. This is one of the other main goals through TV media and so on, all online media, and monitoring of the patients. Now, different ways a registered medical practitioner in any specialty can offer use of this teleophthalmology. It is not only limited to ophthalmologists. Mind you, you have to understand this. When we say teleophthalmology, there is no set definition by Ministry of Government of India or by Teleophthalmic Society of India that it can be practiced only by an ophthalmologist. So here there is one gray area. It is directly from patient to registered medical practitioner or caregiver, that is the people who are working in the field, RMP to RMP, that means from consultant to consultant, or health worker, again these people are working in the field. So this has various subheads. But why these subheads are important to understand is because only the RMP will be liable for any legal action against that particular act or particular thing which you have done. So ultimately the fault is only on the doctor or the organization who has instituted it. Is it safe? Where clinically appropriate, telemedicine is safe, effective, and a valuable modality to support patient care. Early morning we had a session on AI in ophthalmology, and AI based technologies are again coming into the radar of teleophthalmology medical legal aspects, and we have seen there is a referral base which has increased 9-folds to your base hospital. So that means you are using technology to increase your referral and treatment base, but it has to come with not on the cost. It should be a safe and effective modality of treatment. Like any other technology, the technology used for telemedicine services can also be abused by you, by your staff, by the aggregators, and so on. It has some risks, drawbacks, and limitations which can be mitigated through appropriate training, enforcement of standards, protocol, and guidelines. And these guidelines should be used in conjunction with the other national clinical standard guidelines, protocols, policy, and procedures. So what does the law say as of now? Pre-COVID, the law was different. Post-COVID, the law is completely different. March 2022, when the COVID stuck, Government of India at the same time has revisited this, and we will be seeing in the next couple of slides. But the law clearly says that ignorance of the law is not considered an excuse. Current law status, there is currently no law in India specifically pertaining to telemedicine or teleophthalmology. While the Information Technology Act of 2000 dealt with information technology, it did not address any issues in relation to healthcare. Legally, this has led several people to question the legality of telemedicine or teleophthalmology practices, which is happening in India for decades now. It's not only for years. However, GOI and Niti Aayog, as I said, March 2020 revisited this gadget, and they have raised this in Parliament as well. But the Parliament was unable to pass it, so only a telemedicine practice guidelines, this is freely available online, has been passed, and it has been practiced and revalidated in 2022 as well. This has been released by Government of India as telemedicine practice guidelines, which have been incorporated as Appendix 5 of Indian Medical Council Act. These guidelines have been prepared in partnership with Niti Aayog. The purpose of Niti Aayog guidelines, this you have to understand it very clearly. They just wanted to assist the medical practitioner in pursuing a sound course of action to provide effective care. This is just a basic care. Help realize the full potential of advancements in technology, provide information of various aspects of telemedicine or teleophthalmology, and spells out how technology can transmit in any form can change the practice protocols and policies for this patient to give them the best of the care which is available. Now, there are certain guidelines for the people who are using technological platforms. We have seen Remedios and other mobile apps, cameras and so on. They are using certain guidelines, but most of these guidelines have been violated in Indian scenarios. But as a registered medical practitioner, we should not be violating these guidelines. So the technological platforms providing telemedicine services to consumers shall be obligated to ensure that the consumers are consulting with RMP only, with National Medical Council, registered practitioners, and to comply with relevant provisions. Technological platforms are there to assist you and not to make misuse of it. Technology platforms based on AI, machine learning are not allowed to counsel the patients or prescribe any medicines to treat a patient. Only a registered medical practitioner is entitled to counsel or prescribe and has to directly communicate with the patient in this regard. So your people who are working as staff in remote areas, they cannot do any kind of prescription. This has to be, point has to be noted. There are certain, many gray areas. I have picked up some 10 or 12, and this depends on region to region. So one is on the regulatory ambiguity. There is still a lot of regulatory ambiguity as how you are going to regulate as compared to the cities to the rural areas. Scope of practice, quality of care is still questionable mark. Patient safety, informed consent and continuity of care, as well as equity of and access and reimbursement if something goes wrong. Where are we in the court of law? These are set protocols written by Niti Aayog, but it's not that key, this implies to the usage of teleophthalmology. It just collects the basic medical data of the patient and what can be the diagnosis and the possible treatment protocols. To our surprise, when I checked on the list of medicines which are available to be prescribed in ophthalmology, can you name a drug which has been allowed by Niti Aayog or Ministry of Health for the treatment of conjunctivitis on telemedicine platform which you can prescribe? There's only one drug which is ciprofloxacin eye drops. No other eye drops has been advised by Government of India. So there are a lot of gray zones still which are not very clear, so we need to keep ourselves legally safe. However, we should also be seeing that how the AI or the tele-ophthalmological practice is going to change the future for all of us. Legal point of view also, what can change in future. So it can change the reimbursement and insurance coverage for the patient, very important point. Cross-border telemedicine, we are doing it, but cross-border, acceptance of technology or even the challenges which can thrown on the legal sector can also be there. Regulatory flexibility and innovation, also licensing and credentialing, privacy of data, malpractice and liability. So few take-home message which I want to drive is usage of technology is increasing. However, we don't have any clarity as of now from Government of India on the rules and regulations which can protect or destroy you in the court of law. We should always be beware of aggregators, especially on the online platform, who are even selecting patients from the AI-based platforms and getting to you and telling you to treat it. Beware of unregulated insurance providers, beware of online practices. Data can be breached quite easily, and legal protection is still not unclear ground, and as of date, consumer has a upper hand. So can I or can we? Yes, we can use the technology, especially for screening, research, collaborations, and AI-based incorporations. However, we should not be deciding on treatment protocols. Surgical advice is only by RMPs. Online aggregators, we should be careful. Trained manpower is the need of the hour, and be legally safe. Thank you so very much for a patient hearing, and thank you, the organizers, for the wonderful opportunity.
Thank you so much, Dr. Manoj, for nicely presenting about this burning topic of teleophthalmology. As we all know, teleophthalmology is going to be future, and use is going to increase day by day, and with it, the menace of litigation will also increase, as we have seen in the famous case of Sushant Singh Rajput's death case. Our next speaker for today is Dr. Santosh Agrawal sir, President of Maharashtra Ophthalmic Society and leading eye surgeon from Aurangabad. He will be speaking on professional indemnity insurance for ophthalmologist, what, why and how much. Sir.
Thank you, Dr. Viral, AIOS, for the opportunity. Professional indemnity insurance for ophthalmologists. What, why, and how much? Many of the, I think, questions already answered by previous speakers. It is the need of the hour. We have so much threat from our consumers or the patients who are unhappy. So we have to go for insurance. So what is indemnity insurance? How, who needs it, and who gives us? So what is medical indemnity? Insurance protection, protecting medical practitioners from legal action. Indemnity against negligence claims, reputation defense, overseas clinical care, charitable work, good Samaritan works, medico-legal reports, and work from other agencies. So all are covered in indemnity insurance. So what is indemnity insurance for doctors? Which safeguard medical practitioner against legal cases and compensation. So medical insurance, an agreement wherein one party guarantees compensation for losses or damages incurred by another. So compensation for damages or loss, or an exemption from liability for damages. So medical indemnity insurance, the objectives, what are the objectives? To protect the professional interest of the insured doctor, to arrange, to conduct and pay for the defense, and to indemnify the doctor in respect of any claim on ground of professional negligence or misconduct. So which practitioners need this type of indemnity? Doctors in private practice, government doctors who are doing locum in private facilities, and also government doctors who are not doing private practice. All should take indemnity insurance. So why we should take indemnity insurance? Already speakers have highlighted the points about the consumer protection and everything. So for that reason, we need this type of indemnity insurance. Because many unhappy patients or notorious patients, they can lodge complaints against doctor in spite of your good work. So heavy compensation can be ordered by court in certain cases, especially in our specialty retinal cases, ROP cases. In such cases, they can you can have heavy compensation. And domestic as well as overseas patients are there. Nowadays medical tourism is going on, increasing. So we have to deal with overseas patient in metro cities. So that time also you have to indemnify yourself. Your career and profession is at terrible risk. So one should go for indemnity. These are the reasons. While it is arguable that one may have an agreeable working relationship with their clients, this still is no guarantee of preventing future litigation from such patients. Depending on the nature of lawsuit, the legal battle could sometimes persist for years. Even one such incident is enough to liquidate the financial foundation of an enterprise, irrespective of how small or large it may be. Whatever status you have, you can get affected, your career can get affected badly. This is especially all the more relevant for businesses that serve high value, means high value or means VIP people who can sue you and can have great compensation. The clients as the stakes are higher in this case, like LASIK, already I told you ROP and retina cases. Apart from this, the dealing by several organizations is not just limited to domestic clients, but also extend to the overseas customers. So what indemnity insurance gives us? It gives us protection from risk of paying the liable amount after found guilty or negligent. If court gives consider you as a guilty and gives the compensation, then that can be protected by indemnity insurance. Bit like having third-party vehicle insurance. It's just like third-party insurance. The term indemnity insurance refers to an insurance policy that compensates an insured party for certain unexpected damages or losses up to certain limit, usually the amount of the loss itself. Insurance companies provide coverage in exchange for premiums paid by insured parties. Indemnity insurance is designed to protect professionals and business owners when found to be at fault for a specific event such as misjudgment, medical malpractice and errors and omissions. Insurance are examples of indemnity insurance. Even if you are negligent, that can be covered in this indemnity insurance. Purpose of professional indemnity insurance, indemnifying party, that is indemnitor, that is the insurer. Indemnified party is the insured one. The compensation for certain costs and expenses typically stemming from third party damage claims in return for the premium paid by the insured. So exemption from the liability for damage. This is the important part. One party agrees to pay for potential losses or damage caused by another party, that is doctors. So these are the advantages. There are many advantages of medical professional indemnity. For medical professional, it is one of the most important insurance that every doctor should buy beforehand. Risk can lead to lawsuits and they can destroy your service if not covered by insurance. You will need insurance to protect your healthcare services from sudden and shocking claims by the unsatisfied patients. So what is the eligibility for indemnity insurance? Doctors and medical practitioners and other professions like engineers, contractors and architects. Also hospitals, clinics, your paramedical staff, you can take indemnity insurance. So what is covered in indemnity insurance? Professional negligence, loss of data and other documents, loss of goods and money, unintentional breach of confidentiality and of copyright or copyright, claim investigations expenses and defamation, all are covered under indemnity insurance. So what is exempted, what is not included? Criminal acts, frauds or law violation. If you don't obey the law of land, being under the influence of drugs or alcohol while rendering the services, intentional damage to the patient, contractual liability, act of war or terrorism, and insolvency of the person with indemnity insurance. All these are not covered under indemnity insurance. Factors to be considered before taking indemnity insurance. Deciding the right sum, which depends on the nature and magnitude of that particular disease or risk involved. In which specialty you are working. If you are a vitreoretina surgeon, your indemnity insurance sum should be on higher side, like LASIK, retina, ROP. And high value patient, if you are dealing with high value patients, VIP patients, then in those cases also you have to be having a right sum, means larger sum. So what are the limitations of this indemnity insurance? Willful negligence and misconduct or intentional damage. Already I covered that, so I don't go in detail of that. What is the cost of premium of professional indemnity insurance in India? What is the premium you have to pay? It varies as per the profession. So in medical profession, it is 0.3 to 0.5% of sum assured. Is it mandatory indemnity insurance? It is not mandatory, but however, it is an absolute necessity and recommended to protect yourself from legal liabilities. Who provide this indemnity insurance? All government and private insurance companies like ICICI, Lombard and other companies, they provide this type of insurance. No financial interest. How it is calculated? Greater the perceived risk of your occupational, higher the premium will be. Doctor's indemnity is X amount, if is X. Then if you want to include the staff, unqualified staff, then 7.5% additional of doctor's indemnity you have to add, that is Y amount, and then X plus Y plus taxes, that is the total premium. What happens if you don't have a professional indemnification? Patient can lay a claim against you for the losses and inconvenience they have incurred, and you shall need to pay for legal defense and any necessary compensation you lose. A very serious business can disastrously destroy you financially. Your career will be ruined. What is the time limit for PI claims? 6 years. Within 6 years, he has to sue the case. Personal indemnity insurance pay litigation costs, damages awarded by the court. Professionals are potentially liable for negligence, inadequate performance despite the intention of goodwill. Even though you do good work, but unhappy patients can sue you. Thank you very much for your patient listening.
Thank you so much, sir. So, for nicely explaining to us about the professional indemnity insurance for ophthalmologist. So, we will take questions after the our talks are over. So next speaker is Professor Dr. Rajesh Joshi from Nagpur, and he will be speaking on medical records, the most important evidence in the courts of law.
Good afternoon, everyone. Before I begin my topic, I just want to know how many of you are using EMR or electrical medical record for your OPD patients. I think most of you are using electrical medical record for your patient. It's good. Now, what is the importance of record keeping? Evaluation of your own results, data for scientific presentation in conferences, analyze the data for paper publications in peer-reviewed journal, and helpful in medical litigation. The last one is very important. That is why we are here. The legal system relies mainly on documentary evidence in situation of alleged medical negligence, because poor records means poor defense, but no records means no defense. Now, if you see the initial days, we used to keep all the records in a room which used to be look like this. So large room used to be required and difficult to retrieve your record if at all you need for medical litigation, or if you refer to your records previous. If you have any patients who have gone for surgery or in for your consultation. Now, electrical medical records most preferred method because it is neat and tidy, easily to be stored and retrieved, but only problem which is with this record is that you need to have a person who will look after this whole data. If you are only person in your clinic, then it would be difficult to retrieve, may not get time to retrieve from medical record also. So you need to have a dedicated person for that. Data can be easily retrieved, prescriptions is fully typed. That is very most important thing of these medical records. Now we will see one by one how this medical record keeping is important as far as patient care and to avoid the litigation in your practice. Now coming to history records, how it is important. Cataract surgery which went uneven pool, but there wasn't any improvement in the vision, and patient approached consumer forum. Now the operating surgeon is questioned about the result, but the result was in favor of doctor, because in history note it was clearly written that decreased vision in that eye since childhood. That patient had a amblyopia, and the doctor has written in the case sheet that the patient is having amblyopia, so he may not improve afterwards. Documentation of clinical findings, they are also very important. Cataract surgery which was uneven pool, and the patient had recurrent post-op inflammation and iritis with all possible treatment. Eye ultimately went into phthisis because of all the treatment. Patient approached consumer forum about this problem after post-cataract surgery, but the result went in favor of surgeon, because pre-op documents clearly mentioned that patient had a complicated cataract, patient was given pre-op steroids, and everything was done pre-operatively, and patient was explained about the prognosis post-operatively also. So this is how the patient, this is how the doctor escaped from the litigation. Now investigation and documentation of this investigation, why and how it is important. Cataract surgery in diabetic patient, patient did not improve, patient approached to the consumer forum about non-improvement of the vision post-operatively, but the doctor escaped due to pre-op OCT findings which was suggestive of the diabetic macular edema, and the patient was given anti-VEGF. So the documentation of the records about the OCT and everything is very important as far as your medical records are concerned. Now about the pre-op care and its documentation. Patient developed endophthalmitis in early post-op period. Case filed in consumer forum for compensation for non-improvement in the vision and the trauma to his mental and physical health. After the cataract surgery was performed, patient developed decreased vision and patient was diagnosed having endophthalmitis. Intravitreal injections were given and the patient was referred to vitreoretinal surgeon. Vitreoretinal surgeon took proper care of the patient and the vitrectomy was performed, and that is how the surgeon is kept clean because of all pre-op notes. Now about operative notes documentation, that is also very much important. Patient underwent cataract surgery, compromised vision, and the patient filed case post-operatively, but still the result was in favor of surgeon because the record mentioned that the patient is having posterior polar cataract, and as you know that patients having the defect in the posterior capsular area, they are likely to have some complications which the surgeon mentioned on the case sheet, and that is how the surgeon is kept flawless. Now OPD prescription is very important document. You should mention about the name of the patient, date when the patient came, treatment preferably in capital letters, duration of the drops which has been prescribed, and a signature of the doctor must be mentioned, and the review date. Date is very important part of the prescription because it can be manipulated in future as well if something goes wrong, and undated prescription can land doctor in trouble if the patient misuses it. This was the case which happened few days back. Patient developed glaucoma. Post-operatively, patient was given steroids for some period, and patient used it for years together, and patient landed up with glaucoma and lost his eye. But patient thought that doctor prescribed drop, and he developed this problem because of the drop only, and patient sued doctor. But those OPD prescription of the doctor clearly mentioned that the drug has to be used for so much time, for so much duration only. If patient uses this drop for longer period, he is likely to have some complications. So that is how the prescription should be legible, and it should mention about the duration of the drugs and the prescription and the prescribed drops for duration of the days. Discharge summary, another very important documentation. You should mention about the date of admission, discharge, date of surgery, surgical procedure which has been performed, and the treatment which was prescribed. And you should sign it properly with date and the name also. The referral letter is very important because it can be misused later on also by misinterpreting the date or manipulating the date and the month also. The duplicate of this referral letter should be kept with you with the patient's signature. Medical certificate is another very important document. It should mention about the identification mark and should have a patient signature because it can be misused later on also. MCI guidelines for record keeping, this is very important, but NMC in fact, this hasn't been clearly mentioned. For consumer forum, patient can approach as outdoor case within 2 years and indoor case within 3 years, and maintain the outdoor records for 2 years and indoor for 3 years. If patient demands for his case paper, it should be given within 72 hours. In pediatric cases, a medical negligence patient can file if he becomes major, and it should be kept till the patient becomes a major. In summary, medical record is an important aspect in one's medical practice. It not only helps to improve our patient management but develops treatment plan, as well as it helps in the research, as well as to helpful in legal problems arise and suit in consumer forum. Thank you for your patience listening.
Thank you, Rajesh, for your wonderful talk. So, records are very important in court of law. Without records, they won't listen to you. Only one question for him. I think to add that for the discharge summary, you have to add the emergency number also, contact number, emergency contact number. Yeah. And second thing, can we write signed for if your assistant is signing on your behalf? Is it permissible?
It has to be countersigned, it has to be written, checked by, prepared by, and signed by doctor.
Okay.
Your assistant can only prepare the chart and sign it and after you see that sign only then you should sign it. But doctor signature is must. RMP signature is must.
Thank you.
So Dr. Deshpande. So Dr. Deshpande sir is not with us today because of some personal emergency. And so before we start our question and answer rounds, this topic is very important, legal notice received. So what to do? Basically what to do is be prepared and don't panic. So you are supposed to take it. Dr. A. Deshpande sir, a senior most medico-legal consultant from Maharashtra. He is also chairman of legal cell and co-chairman of legal committee of AIOS. So patient is going to send you a legal notice. Once in your lifetime, each and every doctor is going to get a legal notice, a notice from a letter from a lawyer or an advocate. So you should, and the moment you see that envelope or that letter, you are going to get gastritis and upset stomach and anxiety and sleeplessness. But it's a phase and you have to pass through it. So be prepared, don't panic. So what you should do, patient himself or through advocate or through patient can send a notice through advocate or himself or through civil court, consumer court, or through MCI or state medical council, police station, criminal court, which is called as a warrant, or through other agencies such as municipal corporation or health services. So ophthalmologist should not refuse taking the notice. So if you refuse to take the notice, it doesn't mean that you have been absolved. It will taken as granted that you were informed and you were called for your explanation, but you refuse to give your explanation. So it is not mandatory to answer the notice of a patient and advocate, and other notices answer with the help of advocate or medico-legal consult. So always when you receive a notice, you take possession of that notice, duly acknowledge that you have received the notice, and then decide what to do. Usually you consult your advocate friend or a medico-legal consultant and then draft a reply and give. You must have an indemnity insurance with you, as Dr. Agrawal sir has already mentioned, and a medical legal consultant as advisor to keep yourself cool. Just don't panic. When you receive a notice from a consumer court, you have to give written statement in the consumer court. So you have to give an answer in writing. To face and defend better, if it is given with the help of medical legal consultant, it becomes more effective because he has knowledge of law as well as medicine. He can represent a doctor better way than a normal advocate and so can win the case. He can help in maintaining the medical legal records which help in court to win the case. So as Dr. Joshi sir has already emphasized, medical records are going to be the backbone whenever a case is going to be decided in front of a panel of judges. So whatever you have written down, that only will be accepted. So what is there in the medical record? So a medical legal consultant will help you to correct any mistakes if there are there in your records. So you just rectify this records or whatever lacunae are there, they will be filled up, and then you surrender the record to the court or the police. Whenever one receives a notice from advocate, consultant, medical legal consultant, or in criminal cases give statement to police or present in criminal court through your advocate with consultation of a medical legal consultant. Remember, always remember, complication is not negligence, but not knowing that the complication has happened, not taking proper steps to rectify it, not referring, not taking help of proper specialist, leaving the patient on the unqualified or underqualified subordinate is negligence. Doctor will not be held responsible as negligent if the treatment is as per a standard textbook and or accepted professional practice, and still patient suffers loss or injury. Merely because a complication has occurred, it doesn't amount to negligence. Dr. Suresh Gupta versus Government of Delhi, it is held that for every mishap or death during medical treatment, the medical man cannot be proceeded against for punishment. A medical man is not an insurer. He does not warrant successfulness of treatment or cure to patient. In the past, doctor used to be arrested for table death under section 304A, but now with the decision of Jacob Matthew versus State of Punjab, Supreme Court has given guidelines that doctor should not be arrested under section 304A unless opinion is taken from expert doctors or a committee of doctors expert in that field. So there is a very important role of medico legal consultant, as we have already pointed out that because doctors are very poor in medical record. You are a very good clinician, you are a very good administrator, everything is there, but you are very busy, you won't be minding your records. So you are very poor in keeping records. Advocates are poor in medical knowledge. Judges give decision as per the record kept in front of them. Because of poor knowledge of law, doctor is not able to brief the advocate properly, and so he is not able to plead effectively in the court. Ophthalmologist loses the case, and here medico-legal consultant comes in and helps, becomes important in ophthalmic practice. Depend on him and keep yourself cool. Always indemnity insurance is now must. If you are in private practice or even in service or government, you must have indemnity insurance policies. Thank you very much, and we are now open for questions and panel discussions. Yes. Yes, sir. Yes, sir.
An advice to purchase for a new
Ophthalmologist
ophthalmologist.
starting his practice.
Yes.
So it depends on the area where he is going to start his practice, in
metro
which
city.
city.
Metro
in which
city.
So the thumb rule is what is the cost of 1 BHK flat in that area where you are practicing. Take that much insurance minimum. And now with this new coming it, the district court has power of 20 lakhs and state court has power of 1 crore. So if he goes up to 1 crore is minimum if you are in a metro city. So suppose he is in Bombay, 1 BHK will be around 1 crore plus. And if he is in Pune, it is 60-70 lakhs minimum. If it is in Bhopal, it is 40-50 lakhs. So basic, that is thumb rule, but you must decide according to your volume. As your volume goes on increasing, you must increase your indemnity amount also.
Which company?
Which type of practice you are doing, that is also important. Whether you are
Comprehensive
refractive surgeon
ophthalmologist. Comprehensive ophthalmologist.
Yeah, comprehensive ophthalmologist. Whatever he has suggested, that is
Policies are always nationalized insurance companies and private insurance companies. What we have got in our Maharashtra is, we have got a group indemnity insurance through Maharashtra Ophthalmic Society. So all members of MOS who want voluntary to opt for that, they get a very good rate, which is almost 1/10 of what you get if you go directly. So a group of around 1500 ophthalmologists, we have got a group of 1500, we have voluntary opted for that through MOS. So MOS coordinates for that renewal every year, and it is now in the third year. Third year of that policy.
So group insurance policy is best.
It's not a group insurance, it's a professional indemnity for each and every individual, but the rates have been negotiated by a group. So we are getting it for a very handsome
So through our state
government,
society,
yeah.
there are 3 or 4 options like
Yes.
ICICI Lombard,
Yes.
National Insurance, there is Reliance,
United Insurance also there.
etc. So whether you are going through those insurance company for this
We are going through ICICI for MOS.
Lombard,
ICICI Lombard.
Probably
But we are continuing with our old policy also individually, because not a single litigation has arisen till now, and we don't know what will happen when litigation comes, how ICICI is going to respond and help us. So
the retroactive date is accepted by the new company?
no.
No. So the old policy,
Yes.
whatever may be, that should be continued.
It
At
is
the same time
being continued by many ophthalmologists. Some have shifted exclusively to ICICI, but some high volume practitioners, they are continuing their
Both-
old policy
both.
also till we
So
see the
if-
results. Yeah.
Sir, if both policies are running
Yeah.
and one claim comes, who will pay?
Sir, you have to declare to the other company also that you hold this policy also, and whenever a claim comes, it's up to the doctor to whom to give to the notice, to whom to inform. So, but if you didn't inform the other party, he will straight away deny that you are not informed within time 48 hours from getting your notice. So you get a legal notice, you can inform both the parties. They will give you lawyer for both. Both the parties will give you a lawyer in the court.
And both will take care of.
Both will take care through.
So instead of one company, we should have 2 insurance.
No.
better.
One is sufficient, but this is a special case in Maharashtra where we have got a new policy kicking in. So some are continuing with the old till we see the result of the new.
Thanks, sir.
But this
Yeah, and I
holds
think-
good for people who are MOS member but out practicing outside?
You can become MOS member by just paying 3,000.
No,
rupees.
we are a MOS member, but if
Yeah, all over India.
Sure.
Yeah, yeah, yeah. Sir is the president of AIOC.
Now, on the second, on this similar line, the question arises is, you have one ophthalmic insurance, that's not a problem. Do you also recommend to have a IMA insurance as well? Because IMA appoints its own lawyer and it's legally.
IMA, yeah. Sir, you want to add something? IMA is also a good scheme, but IMA is focused for general practitioners. They don't have a focus
No,
for
but,
ophthalmologists.
But what a couple of cases where I have gone through, ophthalmologists who have supported our colleagues, people who had IMA policies, their representation was done by IMA, which is a better representation in the court of law.
It is not that IMA, if you are an active member of IMA helps you in the acute phases. Whenever there is some miscreation.
No, even but
yeah.
the representation was done by IMA, which
Yeah.
and the policy covers only for 25 lakhs.
Yeah. Yeah. MOS will also give you a lawyer.
No, that is okay, but IMA has a better representation in court of law because
They were able to represent better and more strongly. It depends on city to city. IMA is a city branch. So your Chennai IMA is very strong, as we have seen. But suppose in Kanpur it may not be that strong.
No, my question is, do you recommend to take that as well?
Definitely, anyone. I guess you take through your own pocket or go through IMA or go through Ophthalm Society, but take it.
How much risk is upon you that they decide everything?
One more question, whether we should take it in the individual or in the hospital name, indemnity insurance.
Always in your name, as well as vicarious liability should be covered, and your hospital staff, working staff should also be covered, and all the consultants coming there.
So
they
suppose
should be
patient files a complaint against the hospital name
covered.
and the
That
policy is in the name
premium
of the
differs. You have to take it in your name as well as hospital name.
There are some doctors who have only the clinic, OPD clinic. They take their patient to some nursing home and operate. On the same day discharge, and there is no relation with the nursing home after the discharge. Whether this nursing home is vicariously
Yes. Because the patient will send a notice, he will write a story. I went to a consult so and so doctor, he took me that so and so nursing home. I was operated in that nursing home and I got such and such problem. So notice will going to the primary doctor as well as to the nursing home. Notice will be served to both will be become party. So it's always a good idea if you are a nursing home and some doctors are coming to your nursing home and getting their patients operated, you have to take vicarious liability for everyone. And that obviously you don't allow anyone to operate in your unless they have got their own personal indemnity insurance also. First see to it that all the doctors coming to your clinic, they have got their own personal individual professional indemnity insurance, and then when you take your hospital indemnity insurance, you mention okay, so and so consultants are also coming with their case. If you don't mention, it's okay. You will be made a party. Both the doctors will be made a party.
in cases of some complication, we refer the case to regional institute or any government institute.
That will also be a part.
Somebody has occurred, we refer the case to government institute if possible and make arrangement to get it admitted. Whether that regional institute
That doctor will also be made party, but the penalty will only be implanted on the primary surgeon.
It depends on the patient on whom he is filing the case.
No, in this, let me clarify here, sir.
Government setups.
Whether it's a
after complication, it is referred to the government hospital. And after the
For example, is a retina surgeon. I get a patient offend of that, I send to him, he treats for a couple of months, patient doesn't improve, we both are party. He is also going to send his lawyer. But in government cases, patient also knows government kahan se kya paisa they just write the story, they make the doctor a party, government doctor a party, but the claim for amount will be from the primary doctor.
just a personal experience, sir. A patient got operated in Andaman, developed a complication, cataract surgery, was referred to Andaman Government Hospital. They were not able to treat, was referred to Chennai to us through a friendly contact. We are not blaming the surgeon, but how this goes in your context. 3 years passed by, we did treatment for the patient. Patient recovered only 50% vision. That patient filed a case after 3 years. To my surprise, first 2 doctors were not been contempted in that case. We were contempted because we did the last procedure and we didn't mention that the patient was referred as a complication of the previous problem. So here comes the importance of medical records. We learnt it in a very hard way. though we got escape from the case, but it's not that you have referred, your liability or whatever it is just goes away. You can also be punishable. The only thing which is going to speak in the court of law was your record. Our records was poor. We did the treatment, we salvaged the eye, everything was perfect, but our records were poor. As highlighted by Dr. Joshi, even if you are getting a referral patient, even in a general ophthalmic practice, sometimes even a conjunctivitis, viral conjunctivitis is not getting better, will be referred to you for second opinion. Always make sure your record is perfect. I have suffered personally on this, that's what I'm sharing it on this podium, so don't make this mistake again.
And you had to attend the court.
Yes, yes, and that also court was in Andamans. Yes, our legal lawyer went all, that's what I'm saying. So here IMA was at our rescue. The first notice was served by IMA. So again here in my practice, because it was an institute practice, I was not the primary primary director of that institute. The institute director was given a notice that such a such patient has been referred to your hospital and such treatment has been done, and patient has filed a case, and this was a very heavy compensation, 5 crores the compensation was asked. Luckily we got escaped, but these things can happen in reality and we have to be very careful. We went all the way to make, to help the patient, but the patient sometimes they just bounce back.
Sir,
The total history and the case was in Andaman.
Yes.
And you have to fight the case and win there at Andaman.
We won the case. The case got dissolved, but what I'm saying is general scenario that we should be aware. This can happen anywhere. You're not saying it can happen only in
the
Andaman.
most important thing is counseling of patient is very
Counseling
important.
and your record.
Yeah,
We
and
were poor at our records, so we were on the back foot. Your records will only save you.
Many times patients should feel that you are serious about his disease. If you are not serious about his disease, if even if complication occurs, you have to sit with the patient. You have to explain everything to the patient. Then he should be get convinced. You should refer the patient at appropriate time to the experts like vitreoretinal surgeon. Third is records, very much important. Fourth is indemnity insurance. These are the very important things. If we keep in mind, nothing will happen.
And the indemnity will cover only one case per year.
That is mentioned in your policy. What policy you take? It is 1:1 policy, 1:2 policy, 1:4. You can take n number of, but the amount is fixed. 50 lakhs you have taken. For 50 lakhs they will cover you. If it exceeds 50 lakhs, then you have to pay from your pockets.
1:1 is for one case,
Full amount.
Does indemnity cover the compromise amount? If there is any compromise, if there is a mediation and
They do if it is done through court, through mediators, the insurance company, they do give some amount to settle the case. Not after the court, settlement under the eye of the court. They give some mediators, arbitrators are appointed,
And
so that it's not become part of the official court proceedings, but it gets off the record
one
settlements.
of my other friend on the similar note, you should be very careful on touching any cases from the aggregators. One of my very close friend has operated a case referred by an aggregator. Surgery went on well, but the patient had a 0.75 residual astigmatism. Went to another doctor, they said, no, this is gross negligence, you have got all this problem, and the case was filed. Now, the case was filed on the aggregator company, and the aggregator company has given the case ahead to the doctor, because the aggregator company by law is not responsible. So we should be very careful in whatever documents you are signing with your aggregators or your referral sources. So only you are responsible, the person who is touching.
Very important point. I want to draw attention that you should not abuse your friends. Whatever case comes to you, whatever happened, don't disclose that patient doctor has done something wrong. Loose comments should be avoided. That is the main cause for your litigation. Should not abuse your friends, your fellow doctors, ophthalmologists. That is very important thing.
And also in tele-ophthalmology, a lot of things are missed. Almost they say 20% of tele-screening will miss any kind of pathology, whether it is retina, glaucoma, cataract, or whatever it is. So you should be very careful in protecting yourself if you are doing any remote screenings or remote treatment. Very, very important.
Even if a patient of headache comes to you, write down If patient doesn't respond in 4-5 days, go for OCT, CT scan and MRI and neuro opinion. It's better to write down, because if patient comes out with tumors and something like that, he can sue you. You didn't diagnose me properly. You didn't examine me properly. So better to write down whatever you feel.
All the investigation.
Investigation, everything. But you can tell the patient to save the money also. कि ये लेकर देखो, अगर इससे नहीं फर्क पड़ा तो you can go for this test.
Sir, for the cataract, do you advocate routine intraretinal checkup, including macular OCT?
Yes, sir.
Routine.
OCT is a choice,
Preoperative, yeah.
but dilated
Especially if
retinal
you are-
examination has to be done. Sir.
Especially if you are planning for premium IOLs, you must get an macular OCT done.
Sir, it is not mandatory. Everything is not mandatory. But if you have OCT, better get it done preoperatively. But you can mention fundus examination is done. You can draw the
Fundus
diagram.
examination is mandatory.
Yeah, it's mandatory. That is mandatory because it is possible for everybody.
I feel the macular area, including the disc, is within normal limit. Should I look for the investigation like OCT?
Yeah, better.
I have got the instrument in place.
Better.
If you have got the instrument, you must just do a screen. Don't go for printout. Just for your satisfaction, have a look at that graph.
So many times in fundus examination, you can't reveal this macular edema, sometimes ERM, some traction. You can't pinpoint everything. So there are very trivial things you have to go for. Okay.
Thank you so much, sir. Thank you so much for active participation.
There's
A group
document our
photograph.